Well, welcome back to the TuckerAllen podcast. I'm Scott Trout. I'll be your moderator today as we continue to bring you information in general on estate planning and elder law. We'll continue to do that each week. We're joined by our attorneys at TuckerAllen. You can find us on the web at TuckerAllen.com, but keep in mind, as I start every podcast, this is not intended to create an attorney-client relationship, nor is it legal advice. So, this is really an educational, informational session. We want you to get some notes together and take this to visit an attorney. Obviously, our attorneys at TuckerAllen, both in the St. Louis metropolitan area as well as Kansas City metropolitan area, are available for a consult. You can do so by scheduling that on the web at TuckerAllen.com, or in the St. Louis area, you can give us a call at 314-335-1100. So let's get right to it, and let's talk a little bit about some issues regarding estate planning and elder law. I'm joined by Missy Shands Manning in our St. Louis metropolitan area. Welcome.
Good morning.
Hey, how are you?
I'm doing great. How about you?
Good. So, we want to break it down, and this can be, somewhat, people think it's a complicated area because there's always big words and big terms and the things that kind of overwhelm people, and they oftentimes, because it's like medicine, right? You may say something in the word oncology and that scares people. Well, the word estate planning and will scares people. So that's why I wanted to talk to you today to kind of bring it down, make it a little bit easier for people to understand, and maybe talk about what they need and why they need it. And the first thing I want to ask you about is the word inter vivos gift. You see that a lot, you hear it a lot, and it's hard to understand what that means. And so people don't ask the question. So I'm asking, let's talk a little bit about that. Are there problems with that? What does it mean? And kind of walk people through that they're watching right now.
Sure. So an inter vivos gift is a gift made during the person's lifetime. So it's not made in a will or a trust or anything like that. It's just one day you tell one person, hey, here is this cell phone or this car or whatever it might be. And it happens before they pass on.
So are there requirements for that? I mean, maybe I should ask this and back up one step. Why is that important for people to understand what that is? I mean, do they have to have a will already in place to make an inter vivos gift, or do they, work together? Why is it important to talk about and explain this to people?
So an inter vivos gift is important because it doesn't have to be in a will or a trust or anything like that. There doesn't have to be much documentation at all. All that's required is an intent and then delivery of the gift. So I have to express my desire to gift something to you with no strings attached, and then you have to accept it, and I have to actually give it to you. So it could be symbolic. I could give you the car keys. I don't actually have to hand you a car.
So are there problems associated with that people should be made aware of, that things that may cause issues with that intent to give someone a gift?
Yes, so there's a lot of issues that pop up, especially with gifts towards the end of someone's lifetime. Sometimes when it's an older person, they may no longer have capacity to start making gifts like that. They might be on their deathbed and say, son, you could have this, daughter, you can have this. There are problems. If the person doesn't have capacity, a gift can't be made. They can't make a gift legally if they don't have capacity. So if they have dementia or Alzheimer's or something like that, any sort of gift that might be purported to be made is not valid. Mom gave me this right before she died. There's no witnesses to it. There's no documentation of it. But I still want this out of the estate. And that leads to huge problems among siblings. So they may be forced to prove that it was an actual gift to the court. And if they can't prove that, then that gift is no longer valid.
So the whole proof thing seems pretty difficult, and someone could walk in and say, well, prove that she gave it to you. I mean, how is that proof done? Is it, obviously to me, as I'm thinking through this, it's certainly more clear if you just do it in a will, when make your wishes, on paper, that I'm giving, my son this, Timex watch, right?
Yes. So that's why we like to have you set up an estate plan if you are going to be making gifts. Another problem that we frequently run into is people saying, upon my death, you can have this. People say that to their relatives all the time, but if it's not documented somehow in an actual formal will or trust, then those aren't valid. Anyone can say that.
So I was talking with Ryan Foley today and about this whole idea of inter vivos gifts kind of came up. We didn't use that word, but I called it, my grandmother, for example, in her infinite wisdom, decided that the way she would do her estate plan was to pull out a roll of masking tape and put someone's initials on the bottom of, those items, kind of an inter vivos gift, but not actually giving it to them. And that was enough. I mean, I guess that kind of goes along as I'm thinking about proof. You have to prove that that's her handwriting, that was her intent, that you have to even look at the initials. What do they mean? Like some of my kids have the same initials, HCT. She just puts HCT, then how do we know, right? If we don't have a will?
Yep, so it gets very murky very quickly. And if no one's willing to cooperate and figure it out, then that's how we end up in court with extensive litigation.
So moving on, as you think about the process of a lot of questions people have, let's say their loved one passes away and they have some bills that come in. What do you do with the bills? Do you have to pay them? If you don't pay them, what happens? Where does the money come from? Kind of walk people through. That's a big question because they're overwhelmed immediately with what to do.
So you are never responsible for another person's bills unless they're actually your bills. It can get pretty tricky with these debt collectors. They may be calling you, telling you, oh, well, you need to set up a payment plan and all of this other stuff. There's actually a very clear-cut procedure for getting those bills paid, but the creditors are trying to circumvent that procedure by reaching out to you and demanding that you pay these bills and sending them to you. So you never have to pay anyone else's bills. The proper way to go about it is to have an estate opened and have a personal representative appointed, and then that person can schedule a hearing for all these creditors to come and prove their claims in front of a judge. And then the judge decides this is a valid claim and this is not. And then at that point, they have to pay the bills from the personal representative, pays that from the deceased person's estate. So no one has to pay their own money. It would be coming from the deceased person. And there's a long process to go about proving that those bills are actually valid bills and they have to be run through the court.
Does it matter if the person dies with or without a will in terms of the bills and how they're paid or if they're paid?
It does not matter, actually.
So, I imagine the bills, they come from whatever is available. And let's just say, what if there's not enough money available to pay all the bills? Then what happens?
Well, then it goes to the judge, and the judge can tell us how it's going to be divided up. There's an order of priority on who gets what when, but a lot of it ultimately is determined by a judge. And they have to fight and prove their claims and try and convince the judge that they deserve to be paid with what little money there is.
So I guess what I'm thinking through means, you've got this stack of bills, you don't panic, you don't stress, come to a lawyer and let's go through it. And you can let them sit there and notify, I guess, the creditors, hey, this person died. We're going to, follow the court process and we'll be in touch. Kind of the way they should go about it.
Yep, exactly.
Yep.
We had a lot of conversations on what would happen if we weren't here, and I don't know. TuckerAllen was super convenient. It was so easy to go through and get the package that we needed.
The website was simple, easy to use. You could schedule a time to actually meet with somebody.
It's one set fee for a will, one set fee for a trust.
It's our wishes in place. It's everything we want for our daughter.
So you mentioned personal representative. I know people have heard the word executor, and I think they've done away with that word. And what are the duties? What is this personal representative? What are their duties? What are they supposed to do? And I assume that means you only have that once you actually execute a will, right?
So anyone can be appointed as a personal representative. It doesn't matter if there's a will or not. It's just a different type of case if there's a will or not that proceeds through court. So your personal representative is, as you said, an executor or executrix if it's a female. This person is in charge of figuring out where all the assets are, liquidating those assets, selling them off, paying any debts that are owed, including taxes, and then distributing the money, if there's any left over, to the beneficiaries.
So how do they designate a personal representative, or how is one appointed if they don't have a will?
Okay, well, if there is a will and the person that's listed on there is still living and willing to assume that duty, then that person gets appointed by the court when they submit the will to the court and say this person passed on. Then the court gives them letters testamentary telling them that they are now the personal representative of that deceased person's estate. If there is no will, then it's kind of a free-for-all on who wants to put in for being the personal representative. There's some order of priority. Spouse is obviously going to go first, and then children. Or parents if there's no children, but ultimately anyone, even a creditor, can be appointed as a personal representative.
Doesn't sound like I'd want a creditor to be my personal representative, but
no.
So I think as I was listening to you explain, personal representative, I'm thinking, okay, what if I do something wrong? What happens? Do I go to jail? Is there liability as a personal representative? If I just make a simple mistake that unintentional, meaning, nothing nefarious or criminal, or stealing, but just a simple mistake, what happens?
Okay, well, there is a little bit of liability in becoming a personal representative for someone, so I wouldn't recommend taking that job on if you weren't ready to stay on top of your stuff and be organized and try and avoid stealing and all those other things that would get you in big trouble. But usually a casual mistake that's just a minor one, that's fixable, no big deal. If you do something particularly wrong and you breach your duty to the court and to the person's estate, then you could get in trouble. You wouldn't go to jail. It's not criminal punishment. If you steal, that's a criminal thing, but the actual act of messing something up like that, you wouldn't go to jail. But you would have to return the money or whatever it is and make the estate whole again. So there is a process called bonding, which the judge usually require if you're not a close relative, which says basically it's insurance that you're not going to mess anything up or steal from the estate.
If I'm drafting a will, and I'm just thinking through this, can I provide immunity to my personal representative, or out of the estate if they were to make a mistake that says they're not personally liable, that anything that happens comes out of my estate?
So to some extent you can waive bond in a will. So you can say that, well, I'm not going to require bond. But ultimately all of the probate cases are overseen by a judge, and the judge gets to make the final decision on if you've done wrong. So.
Yeah, and I was just thinking through as people are, well, gosh, as personal representatives, it seems kind of risky, but it is someone who will execute your wishes, right?
Yep.
Okay. So I know people have heard the word small estate, and they can mistake what that means and say, oh, I'm a small estate, I'm good. What is a small estate in the probate or estate world?
So a small estate in Missouri, it's under $40,000 worth of assets after you subtract out things like funeral costs. So it's a smaller estate. So there's not millions of dollars or hundreds of thousands of dollars to be distributed. It's just under $40,000 in Missouri. Other states have a different threshold. So since it's a smaller amount of money, the courts assume that there's less risk involved. So it's a faster, easier, cheaper probate process. So if, for example, someone had a trust but didn't put everything in the trust, usually we end up doing a small estate to do those last few items like a car or something along those lines. And it's just much cheaper, much faster. Instead of 8 to 16 months for a full probate case to be finished, it might be a month or two.
So it sounds easy, but is there a downside to a small estate?
Yes, there is. So the person who is applying to become the affiant in a small estate, so it's like an executor, but they have a different word for it. That person is swearing to assume and pay all the debts of the deceased person. So if it ends up that you are going to take on this small estate and handle, $40,000 worth of assets, and then all of a sudden you get a $100,000 bill, you're in big trouble because you've promised to the court that you're going to pay those bills. So there's issues with that. So you have to be careful and talk to an attorney about potential bills before we go forward with a small estate case.
Which really brings up the question. I'm thinking, as you mentioned that, it made me kind of recoil. I'm like, why in the world would I ever go or try to risk something without a will and risk, someone I love or a friend who has to open a small estate and risk perhaps personal liability? So how do you avoid something like that? How do I avoid a small estate? How do I avoid probate? How do I avoid my things being decided in court? I know that's a kind of all encompassing, but really because it comes down to, what are people that are listening? What should they do?
Okay, well, obviously the best answer is to set up a trust. Anything that's in a trust avoids probate because your trust doesn't die. It's not a living thing. Think of your trust like a basket. You're going to put all of your assets into the basket. And then when you pass away, the basket is handed to your successor trustee, who's the person who takes care of your assets and distributes them just like an executor would. So since all of your assets are in the basket, you don't have to worry about probate. That is the easiest and simplest and surest way to go about protecting yourself and your family. However, there are certain things called non-probate transfers, like transfer on death designations on your car title or payable on death on your bank account, that will also avoid probate if the person listed is still living. So if you and your husband pass away at the same time and he was transfer on death on your bank account, well, then that asset still has to go through probate. So most of the time, a will is a better, safer option. But if necessary, we can still do those non-probate transfers.
So I'm healthy, I'm young, there's no reason for me to be thinking about my death. Is that the wrong thinking in terms of whether or not I should plan right now?
So as an estate planning attorney, we want you to live a long and happy life, but we also want you to be planning as if you were going to pass away tomorrow. We want you to be thinking, what's going to happen to my family? What's going to happen to my assets? How can I protect them?
Yeah, I mean, and it's not morbid. It's one of those things. I mean, I would say I always have a conversation I did with my grandparents about it, and they were older and they just felt like, oh, I got plenty of time. And I think it's one of the reasons I think that this podcast is important is to break it down. It's like learning to eat healthy, right? You're not sick. You don't have anything on the horizon. You don't need to think about it, but hey, let's just take care of what we have and do it now while we have time. And I think, if not now, when are you going to do it? Right? That's the big question.
None of us can foresee the future. None of us know when we're going to pass on. So while it's tempting to keep pushing it off, it's not something fun to think about. It's definitely something that you need to think about.
Yeah, and I think the point of why I think these are important again is it's really to describe what it is. I mean, it's the big question, the mystery out there with all these big legal terms and a lot of misconceptions. And I think maybe we'll talk about that, in another podcast are, what are the misconceptions in wills and trusts and whether you need them or not. I just think that getting this information, trying to break it down like we're doing today, just with real simple terms, we're not able to give everyone, listening and watching kind of the full picture, but just the tidbits that'll spur a great conversation. And as we kind of round out our time today, there's a word as we talk about big terms, ancillary estate. What is that? I know, you hear it. When I see such a big word, I just want to ignore it, but I know we can't. What is it?
So an ancillary estate is one that is open in another jurisdiction in addition to the one where you live. So that's a little confusing. So let's take this hypothetical. Scott, you own your house here in St. Louis, and you own a house over on the East Coast somewhere. If you pass away with just a will, nothing's in a trust, we'll have to open a probate estate here in St. Louis to take care of your assets here in St. Louis. Then we have an ancillary estate over on the East Coast to take care of that house there. So you not only have one probate case, you also have a second probate case going through the system. So that's double the work and double the headache, double the legal fees. So ancillary estates are something that we want to avoid if you own property outside of one state. And the best way to avoid that is to put it in a trust.
If I have it titled, let's say it's myself and my wife, but my wife survives me, does it still have to go through kind of that estate process in another state if it's not in a will or a trust?
No, as long as your wife is still alive.
Got it. Or a relative, right?
Okay, so if it's a relative, though, you guys don't own the property as joint tenants with right of survivorship. Into a problem, your half of it would go through probate and you would have an ancillary estate. But if with your spouse, you guys own it as joint tenants with survivorship, and she would end up owning the entire thing herself, and there's no probate.
Yeah, that's a big point. I think that a lot of people don't understand is they think, oh, it's joint titled, I'm covered, and especially if it's not their spouse. So I think that's why we want to raise issues like this. And I think that's a huge point for people watching right now is I know you think you're doing the right thing, but let's assume you have done the right thing. It's worth, I think you'll agree, go have an hour consultation with someone who practices exclusively in estate planning. Let's look at what you have, make sure you're all covered, right?
Yep.
Yeah. Whether you choose to do a will and a trust or not, whether you have one or not, at least get the information to make an informed decision. It's like having cancer and you're deciding whether I want radiation or chemo. You may choose to do nothing. It's obviously, but having the understanding of what your options are is equally important, right?
Yep.
Yeah. Well, Missy, thanks for joining. I know we're out of time, and I know is a quick topic just to give people a little bit of information that'll spur them to go have a consultation. I know you're available to do that. You can reach them. You can find them online at TuckerAllen.com. You can actually schedule a consultation online when you go to the website, or you can give Missy or the other attorneys a call at 314-335-1100. So thanks for joining, Missy. Appreciate it.
Thanks, Scott. It was a pleasure talking to you.
Yeah, stay tuned. Continue to watch for information like this. We'll bring a podcast to you weekly with information regarding estate and elder law. We'll continue to take a deeper dive into this topic to try to give you the relevant information as it relates to the things that you own and how you can plan for the future. So until next time, have a great week.